Good Thursday morning. I'm Oliver Greenwood, and I'm the former president and current member of the CCCBA Board of Directors. On behalf of the Contra Costa County Bar Association, I'd like to welcome you to Day 2 of the 27th Annual MCLE Spectacular. We hope you enjoyed yesterday's programs. We have a full slate for you today, including Dean Erwin Chemerinsky as our keynote speaker. He'll be talking about the internet. Can't wait to hear what he has to say. This morning's session, How to Get Rid of a Dead Body, is presented by the CCCBA Estate Planning and Probate section. I was thinking about how to get rid of a dead body, and I came up with a card trick to demonstrate that. What I'd like you to do is I'd like you to take a look and think of any one card here in this selection. Take a look. Think of one card. Got it? Good. I'm going to take one of these cards because I'm thinking of how to get rid. Let's see. Okay, that was a good selection. So I've made my selection. You've made yours. And you'll see that your selection is no longer in the deck. We've gotten rid of your dead body. Not only have we gotten rid of your dead body, we've completely made it vanish from the deck. Thank you. Our sponsor for this session is the MS Domingo Law Group. I'd like to introduce at this time Mika Domingo, founding managing attorney of the MS Domingo Law Group, who'd like to say a few words.
Thank you, Oliver. Hi, I'm Mika Domingo of MS Domingo Law Group. I am thrilled to be a sponsor of this MCLE Spectacular session. I have been a proud member of the CCCBA community since I was a law student and was the recipient of a scholarship from the women's section. MS Domingo Law Group has benefited from the support that CCCBA provides attorneys in many ways, such as strengthening my practice by attending outstanding MCLA programs, such as this one put on by our many fantastic sections, building my business through participation in CCCBA Pro and the LRIS, supporting the DEI committee in creating a more inclusive legal community, authoring articles for Contra Costa Lawyer magazine and learning from other member authors, and growing my leadership skills through involvement in sections, committees, and the board of directors. Thank you to all of the CCCBA members who have supported me in my legal career. Together, we make a positive difference in our community.
Thank you, Mika, for your sponsorship and continued support of the Contra Costa County Bar Association. Our event and program sponsors are very important of our CCCBA community. They make it possible for us to provide events like this. Please support us by supporting them. Please take some time to visit the virtual sponsor booths on the SPEC site. A couple of reminders. For assistance, any technical difficulties, head to the tab on the event's main page. Don't forget, while this program is pre-recorded, the speaker is available live in the chat to answer questions during the presentation. They'll also be available in the live Q&A immediately following the presentation. At this time, I'd like to pass the program over to Catherine Korn, the president of the Estate Planning and Probate section, who will introduce today's speaker.
Thank you, Oliver, and welcome to all the attendees. Before I introduce our speaker, I'd like to point out that you will not be receiving any MCLE credit for Oliver's presentation. Today, I'm going to introduce Daniel Kim. Daniel is an attorney with Weintraub Tobin, where he specializes in trust and estate litigation, as well as trust administration. And Weintraub Tobin does have 5 offices in the state of California. Daniel will be presenting today from his Sacramento office. So welcome, Daniel. Program is yours.
Thank you, Catherine, for the very kind introduction, and thank you to the Contra Costa Bar Association for the invitation to speak at this year's event. I'm honored to be in the company of such distinguished speakers, and I hope that you find today's talk helpful. The title is How to Get Rid of a Dead Body, Laws and Regulations dealing with the treatment and disposal of human remains. It's interesting, I wrote an article on this topic, same title, a couple of years ago, and it was very warmly received, and I was invited to talk on the topic, so I'm happy to do it here to this group. I will say, though, that there was one person who reached out to me and said that she was offended by the title, and so if any of you in the audience are offended by the title, I, of course, did not mean to offend anyone, and I was just trying to make light of a somewhat serious topic. And I wanted to write on the topic and present on it because I got the sense that this was an area of the law that was not very well understood among litigators and estate planners alike. I was dealing with a lot of questions, even in my litigation practice, with clients who had questions about post-death issues. I was running into estate planners who had similar questions, and so I saw an opportunity. And I think some of the gap in knowledge is in part because you don't see a lot of litigation or appellate sort of opinions on these sorts of issues. It's dealt with at county levels, and I think most situations are resolved without litigation. But then also, I think the regulations and the laws that do control are very under enforced by the police and other governmental agencies. And so for those reasons, I don't think we see as much of it as maybe we would want to be familiar with the concepts and the laws. And just to start off, I wanted to share one quick story of an extreme enforcement issue of the laws that relate to this stuff. After writing the article, I was contacted by an opposing counsel of mine, Ken Gorman, who's a very skilled litigator in the Santa Cruz area. And he shared with me a story that he told me I could share with the group, which is that I guess about 7 years ago, his cousin was on a road trip across the Western United States with some of his motorcycle buddies, and they had cigar vials of the cremains of 3 of their friends. And the plan was to make stops along the favorite spots along that route to dispose of the cremains. And they stopped at Mount Rushmore. And one of the gentlemen was disposing of the cremains at an overlook in a smoking area. You can kind of imagine a cigar vial and spreading some ashes. And apparently one of the park rangers came up behind him, pointed a gun at the back of his head, ordered him to freeze. And I guess they started discussing the issue. He was under arrest temporarily for 2 hours and was issued a $150 permitting fee. But the ranger decided not to press charges, and the gentlemen were allowed to move on with their road trip. So these issues do come up, and I'll talk about some of the ways that I've encountered it in my practice as we move along the topics today. But my goal for today was to provide a general overview of the topic, the regulations, the laws that deal with the disposition of human remains, some of the common issues that we run into. My focus is not on the criminal aspects. Of course, there are a lot of penal code sections that deal with violations of related issues. Grave robbers, for example, will not be talking about any of that. So the first section here that I have is on the statutory and regulatory resources that govern this issue. The control and disposition of human remains spans numerous statutory and regulatory schemes at the local, state, federal, and international level, depending on the location of the death and the desires of the decedent family with respect to the disposition. A person may wish to have his ashes scattered on the white sand beaches of the Caribbean. Maybe that's where he honeymooned with his wife. I have a colleague here who admitted to distributing ashes at Disneyland for one of her close friends who that was their happy place. And of course, that's actually illegal, as I'll talk about later today. To dispose of cremains or other human remains on private property requires the consent of the landowner, and I doubt that my colleague here had obtained such consent. Of course, no one statutory or regulatory scheme covers every possible scenario. Internationally, of course, laws will vary country by country. At the federal level, there are statutory schemes that do relate to these issues. The Environmental Protection Agency, the EPA, and the Transportation Security Administration, TSA, have regulations regarding the transportation and disposal of human remains. We'll touch on some of those topics in today's discussion. For example, a non-cremated body just a body or ashes may be disposed of at sea, but you cannot dispose within 3 nautical miles of the ocean shore under the EPA. And of course, travel with remains is regulated by the TSA and private airlines. So these issues do touch a lot of different types of laws. But in most cases, the legal requirements that are relevant for you and your clients, I think, are regulated at the state level and the county level. Division 7 of the Health and Safety Code is actually entitled Dead Bodies and provides numerous statutes relating to the handling of human remains, including such issues as the custody and duty of interment, burial, the Uniform Anatomical Gift Act, embalming and transportation, and disinterment and removal. Health and Safety Code sections 103050 et sec govern permits relating to the disposition of human remains, such as permits for disposition, permits for remains to be transported into and out of the state, disinterment and removal permits. And the removal of remains is an issue. I actually had a litigation case where the family owned quite a large area of land, and there was a family funeral, family cemetery on the property. And with how the properties were going to be divided, there was consideration of potentially moving the cemetery from one part of the land to another. So these sorts of disinterment and removal issues do come up. They are somewhat rare, but they do come up. Government Code sections 27460 et sec prescribe the duties of a coroner, including inquests and autopsies when those issues arise. Lastly, governmental agencies, the local ones, county level, have ordinances and regulations that may apply to the transportation and disposal of human remains. Many of the permits, of course, death certificates and other formal documents are obtained at the local county level, as some of you may have dealt with. So the first topic here is the control of remains, the threshold issue here. Who has control? Health and Safety Code 7100 is the statute to look at on this issue of who has control. The right to control the disposition of the remains of a deceased person, the location and conditions of interment, and arrangements for funeral, goods and services to be provided are specified in this statute. And in the statute, there's a list of individuals in order of priority who can control the disposition of the deceased's wishes, unless there's other directions in writing, and we'll get to that in a minute. But the statute actually starts with an agent under a power of attorney here, the second bullet point. But if you go further down, the statute clarifies that for military personnel, if there's a DD Form 93 designating an individual to control the issue of disposition of human remains, that form supersedes all of these different classifications and individuals listed here. So if you're dealing with a decedent who is a member of our military force, then I would check for that form first before moving on to this statute if there are no written instructions. So the first, after the DD Form 93, the first category is an agent under a power of attorney for healthcare, advanced healthcare directive. And of course, if there is such a document, it must comply with Probate Code Section 4673 for such a document, namely the requirement that such a document be notarized or witnessed by 2 individuals. If there are multiple parties under one classification, say surviving siblings, the majority of them control. I actually have a highly contentious case right now involving 3 surviving sisters of a deceased sister, and 2 of the 3 are aligned, and there was significant animosity and disputes over disposition of the deceased sister in another state. Ultimately, the one, after much effort, finally conceded and admitted that the 2 majority members, siblings, could control disposition of their sister's remains under the statute 7100. 7100.1, the section that follows, concerns the writing requirement or the requirements for a writing that controls disposition issues. We'll talk about that in a moment. And interestingly, if the written directions are in a will and there's a will contest, the the directions regarding disposition of human remains, who can control what needs to be done, those provisions are to be followed even if there's a will contest or some other issue with the will. I think some of the public policy reasons for that are that these issues of disposition are somewhat time sensitive, and so and while will contest litigation can drag on for quite some time. So with the control of remains, obviously there can be disputes over control of the remains when not surprisingly, when the decedent was a victim of murder or related crime, and the individual charged with the crime is a person who has the right to control disposition under Section 7100. That right actually passes to the person next in priority, and should the charges be dropped or the defendant acquitted, his or her right to control disposition is restored. I don't know how much that actually plays in practically speaking, because with the time it would take for maybe a defendant to get acquitted or the charges to be dropped, that may just be too long for a body to be kept in refrigeration or the like. Parties who dispute, who's vested with the authority to dispose of remains under Section 7100 may petition a court of competent jurisdiction for an order to control the disposition of remains. If the person with the duty to act under Section 7100 fails to act or cannot be found within the statutorily required period of time, which is 7 to 10 days, the right passes to the next person in priority. And we can compare that, I think, to the probate code section for nominated executors. Probate code section 8001 deals with situations where an executor, a nominated executor, fails to act, and within 30 days, the right can be relinquished or waived, and the next person steps up. And I do think again, the timelines for some of these issues are much shorter because issues relating to the disposition of human remains is time sensitive. I've had recent experiences where a funeral director, funeral home, was dealing with parties who were disputing disposition issues, and they were very upset that this poor lady was being kept in the situation that she was in without resolution, while family members disputed things. I think there is, even in the case law, there's repeated references to the respect that we owe to deceased individuals and the peace, and that we should not be disturbing the repose of deceased parties. That's a theme that we see a lot in the litigation that ensues in these areas. Health and Safety Code 7105, when disputes regarding disposition of funeral arrangements arise between persons with equal priority under 7100, the petition can be filed in the Superior Court in the county of the decedent's domicile for the determination of the person who has control of disposition. The court, under a petition under that section, is required to make an order directing that person to make interment of the remains and setting forth an alternative order of who shall act if the person appointed by the court fails to do so within 7 days. In general, the person who has the control of the decedent's remains also has the duty of interment, which includes the liability for reasonable interment costs. The authority to dispose of the remains vested under Section 7100 is exclusive. And there's a lot of case law, not a lot, but there's some case law that really clarifies this. For example, there is no right to an autopsy for civil discovery purposes. We'll touch on that a little bit later. The person authorized to act under Section 7100 has exclusive control over funeral and burial arrangements, including invitees, which understandably may give rise to disputes among interested parties and family members. I actually had a case this past year where the client's wife had sadly committed suicide, and family members of the wife suspected, unfortunately, that my client, the husband, surviving spouse, had murdered his wife and wanted an autopsy. I think they thought a second autopsy would reveal some foul play. But the criminal investigation was concluded. No charges were filed. The death was deemed a suicide. and my client decided to move forward with the cremation, and the family was very upset by that. But this just confirms that the authority under 7100 is absolute and exclusive unless you file a petition under 7100. I think in this situation, they would have had to file some sort of motion to stay and to assert their rights to protect the body. But again, the case law is against such parties. I'll get to some of the case law and what the courts say about this issue, but it's very rare that a court will authorize, and maybe there is no support for it, where a court would authorize autopsies and disturb a decedent's rest. The authority vested in this person under 7100 is exclusive. One of the more interesting examples of this is a case from 1984. It's called Ross versus Forest Lawn Memorial Park. For those interested, the citation is 153 Cal App 3D 988, and it concerns, sadly, the death of a 17-year-old girl. And I'll just read a short excerpt from this case. Many punk rockers attended both the funeral services in the chapel and the gravesite burial services. Neither their appearance nor comportment was in accord with traditional solemn funeral ceremonies. Some were in white face makeup and black lipstick. Hair colors ranged from blues and greens to pinks and oranges. Some were dressed in leather and chains and twirled baton-like weapons, while yet another wore a dress decorated with live rats. The uninvited guests were drinking and using cocaine and were physically and verbally abusive to the family members and their guests. A disturbance ensued and grew to the point that police had to be called to restore order. I am a father of 2 daughters. I just can't imagine this sort of thing happening at a funeral of a 17-year-old girl. How sad. But this case confirmed the rights that people have under Section 7100 to control funeral arrangements, guests, invitees, and those related issues. The court confirmed that the right to control the disposition of the remains of the deceased, as set forth in Section 7100, must include the right to private funeral and burial services, end quote. So we've talked about who controls the issue, and now the question is what controls the disposition issue. The legal requirements, this is Section 7100.1 that I referenced earlier, require that the decedent's instructions for disposition clearly and completely set out their wishes in sufficient detail, and then that they have arrangements made for payment to accomplish the intent that they've memorialized. If the decedent's instructions, and this is a point I made earlier, is set forth in a will, those instructions are to be honored even if there's a trust contest. If an indigent decedent has made no provision and the estate is insufficient to provide for interment, no duty is imposed. And in those cases, the coroner of the county can step in and take care of things. So what if the decedent does not have instructions? And this can be very frustrating after a decedent's death. This past year, I had probably one of the most contentious situations regarding post-death disposition issues. This is the case with the multiple sisters, and attorneys for multiple parties were contacting the funeral home, harassing the poor lady who was the funeral director, trying to force her to abide by their wishes, throwing out powers of attorney and other legal documents that really had no bearing on the issue. Eventually, the funeral director got so fed up with the process that she said she wasn't going to talk to anyone else and not do anything until a court ordered her otherwise. And thankfully, we kind of simmered down from there, and I convinced her that she could proceed with a written agreement among the parties. And so we proceeded in that fashion. But I think, obviously, after a person dies, not only are there issues to resolve, but there's the emotions are heightened, people are trying to grieve. And so I think that combination of factors really makes some of these situations very difficult to navigate sometimes. And I think that's maybe goes to one of the bigger takeaways and points for today, is that as estate planners and maybe litigators too, it's good to be mindful of provisions, laws on this topic so that you can write in those provisions in advanced healthcare directives or wills or other documents, and advise your clients and their families on issues that relate to this. It's a shame when these issues arise after someone has passed away. It's the last thing that anyone wants to be fighting about, I think. So there are some immediate concerns post-mortem that I wanted to touch on. You know, as I said, it's difficult to deal with issues after someone passes away. I think, although for some people, right, dealing with these things can be a welcome distraction to the grieving process. For others, they're going to want to not deal with these things and focus on just grieving. But in any event, there are things that need to be done. For example, before a funeral can be arranged, it may be necessary to arrange for a coroner to perform an inquest or an autopsy to be conducted, or maybe the decedent had wishes regarding organ donation that need to be honored. So some of the more common immediate issues are covered in this section, including anatomical gifts, inquests, autopsies, deaths while abroad, and death certificates. An anatomical gift is defined under the Health and Safety Code as a donation of all or part of a human body to take effect after the donor's death for the purpose of transplantation, therapy, research, or as education. Such gifts can be made to a hospital, accredited medical school, dental school, college, university, or organ procurement organization for research or education. And I think what is lesser known actually is that individuals have a right to make an anatomical gift directly to another person. Maybe they know their death is impending and they know someone who needs such a gift, and they can make a specific request of an anatomical gift. If the decedent has specified the recipient of an anatomical gift, the gift passes subject to the rules set forth in Health and Safety Code section 7150.50, depending on the purpose of the gift. If the anatomical gift, the part cannot be used for the named individual that's specified, the organ passes to the appropriate eye bank, tissue bank, or organ procurement organization. Additionally, if the gift is not for the proper purpose, it has to be for a proper purpose, which is defined as transplantation, therapy, research, or education, the gift lapses and the control of the anatomical part passes to the person under obligation to dispose of the body or part. That would be the person designated under section 7100, for example. So for anatomical gifts, how do we properly make an anatomical gift? There are a few different ways. You can use a power of attorney for healthcare, advanced healthcare directive, other writings that clearly satisfy the rules, the requirements under 7100.1. The Donate Life California registry through the DMV process is one way of doing it. This is an important point. The revised Uniform Anatomical Gift Act allows a DMV designation to supersede what is stated in an advanced healthcare directive, unless the directive specifically revokes the DMV designation. So I think for the planners out there, maybe take another look at the advanced healthcare directive and consider perhaps putting in a provision, if you don't have one already, that specifically revokes the DMV designation. I think in my experience and in talking to colleagues, people I think tend to be more focused on issues in an advanced healthcare directive than they are maybe with the DMV designation process. I would think that maybe their intent is more clearly considered and expressed in estate planning documents as opposed to what they do at the DMV. But so that's an important piece to keep in mind, I think. Unless the decedent has validly expressed a refusal to make an anatomical gift, other individuals may authorize an anatomical gift in the following order of priority: authorized agents under power of attorney, the decedent's spouse or domestic partner, parents, adult siblings, grandchildren, and grandparents. Again, if the decedent has not expressed a refusal, then those individuals can make an anatomical gift. That's Health and Safety Code section 7150.40. Interestingly, following the grandparents, the next authorized class of persons who can authorize such a gift are those who exhibited, quote, special care and concern for the decedent during the decedent's lifetime. And that class of persons actually takes priority over guardians or conservators of the person. and other third parties having authority to dispose of the decedent's body. If the decedent's donor was known to possess religious beliefs, that's the last bullet point here, that would be violated by an anatomical gift. Only that donor can authorize the donation. So, it's a less common issue, but religious beliefs can trump and control a lot of these issues regarding disposition and donations of anatomical gifts. With anatomical gifts, there can be conflicts between those anatomical gift desires of family members and those expressed by the decedent, conflicts with those gift intents and inquests and autopsies. So pursuant to a valid request, the coroner may permit the removal of organs that constitutes a gift, even when an inquest is required. And if no autopsy is required, the organs comprising the gifts may be released. If an autopsy is required, but the coroner and the county medical examiner agree that the removal of the gift will not interfere with an inquest or autopsy, the organs may be released. So I think some of the issues with inquests and autopsies can supersede gift requirements, but I think they do try to work with the intent of the decedent and with the wishes of the family with gifts where possible and where these conflicts do arise. An inquest is an inquiry into the manner and the cause of a person's death. An inquest can be initiated by the county's chief medical examiner or attorney general, district attorney, sheriff, city attorney, or chief of police. It's required in a variety of circumstances set forth in Government Code Section 2741. For example, such inquests are required in any case of violent, sudden, or unusual death, unattended death, accidental death, death suspected to be caused by a contagious disease, death of a person not attended by a physician within a period prior to death, and deaths resulting from criminal activity. After the inquest, the coroner has 90 days to deliver the decedent's property to the appropriate party. It's in the Government Code section cited there. In an autopsy, and some of these statutes are similar, right? I think these lists of people who can make decisions post-death are similar between anatomical gifts, autopsies, and here with autopsies, it can be performed if the decedent has authorized an autopsy in writing by will or some other document, or if there's a written request from any of the following individuals: the surviving spouse, surviving child or parent, a surviving brother or sister, any other kin or person who has acquired the right to control disposition under Section 7100, a public administrator, a coroner, or other duly authorized public officer. The relevant statute here is Health and Safety Code 7113. And the written instrument or will, it's interesting. The statute says that it can be that autopsies can be performed and authorized upon the receipt of a written authorization, telegram, or a verbal authorization obtained by telephone and recorded on tape or other recording device from a person representing himself to be any of those following individuals. If such authorization is contained in a will, the autopsy may be performed regardless of the validity of the will, this is the point I made earlier, in other respects, or of the fact that the will may not be offered for or admitted to probate until a later date. The cost of an autopsy is borne by the person requesting the autopsy. Additionally, in limited circumstances, the authority to perform an autopsy can be derived from a coroner's inquest. Again, if there's objections or opposition based on religious grounds, the adult may execute a certificate of religious belief stating that an autopsy would violate his or her religious beliefs. And the decedent's wishes, of course, again, the public policy that courts have towards respecting the intent of decedents with the disposition of their own bodies is it's very well established, and it's only going to be set aside by a court if the coroner reasonably suspects that the death was caused by criminal act or contagious disease that constitutes a public health concern. Autopsies and court actions. The statutes authorizing autopsies are strictly construed, and I mentioned this a little bit ago, that even in civil actions, litigants should be aware that there's no court-ordered autopsies. They're just not permitted for discovery purposes. There's a case, Walsh v. Caden, 1991 case, 232 Calap 3D 159, that talks about this. The courts of this state have no legal authority inherent or expressly conferred to disturb repose of the dead as an aid to civil litigants in their trial preparations. And the court kind of shares some of the logic here that respondents, in this case, owed no duty to preserve evidence because the law recognizes a human corpse is not just another piece of physical evidence. There's a clear distinction between examination of physical evidence, such as handwriting exemplars, fingerprints, written statements, and the body of a human being. Those are very, very different things. And so the former are susceptible of examination without the likelihood of outrage to the emotional feelings of the living. And as reflected in our laws, our society extends more respect to a dead body than to other physical evidence. I don't think any of these comments and public policies surprise any of us. And even in criminal cases, it can be hard to get autopsies. In a 1980 case called People v. McNeil, the defendant there was accused of murder. The victim died early the morning of December 22nd, and the coroner had performed an autopsy the same day. The victim's family was understandably in shock. They expressed a desire to complete the funeral before Christmas. And in accord with the wishes, on the afternoon of the 22nd, after completion of the autopsy, the body was released by the coroner to a funeral home. The funeral services were held for the victim in the early afternoon of December 23rd. Understandably, they just wanted to get it done before Christmas. And immediately thereafter, the body was cremated. And the criminal defendant in that case argued that the coroner should have kept the body in cold storage or instructed the family not to cremate the body so that the defendant could conduct a independent investigation autopsy into the cause of death. And the court rejected the argument. Quote, quite apart from its more ghoulish implications, defendant's criticism overlooks the fact that prosecutorial agencies have no right to custody of the remains of a deceased. Therefore, no duty of preservation arises. So even in the criminal context, it can be hard. Of course, I'm not a criminal attorney, and so I do defer to criminal attorneys on this issue, but I did find this one case that I thought was relevant to mention today. Embalming is a process in which blood is drained from the body and replaced with fluids that delay composition. The process is typically unnecessary in this day and age unless you're transporting the body by common carrier. All bodies must be embalmed or refrigerated if final disposition will not occur in 24 hours. And typically, I think these days, refrigeration is a common course unless you're transporting the body by common carrier. Deaths while abroad. In the unfortunate and rare event when a California resident dies while abroad, I think it's important, obviously, to consult with the U.S. Department of State or the U.S. consulate in the country where the person died to navigate the situation. I think all of us would expect that the laws would vary from country to country. And so I think in navigating transportation, maybe burial, whether it's here or there, death certificates that may be needed, those need to be coordinated with the State Department and consulate for that country. Typically, I think where expenses are paid in advance, you can coordinate all of these things and have burial here or there and arrange for other disposition of the decedent and shipment back to the U.S. We'll talk about shipment in a little bit. If a death certificate is required from a foreign country, just one point here about authentication issues. Sometimes death certificates, birth certificates, and other sort of documents, governmental documents from other countries have authentication issues. There was a case, Estate of Herzog, where birth certificates were attorneys that tried to get it into evidence, and it was rejected by the court because of authentication issues. I actually dealt with a case where I was dealing with a medical certification from Mexico think it was a conservatorship case, and we had trouble admitting it in Sonoma County. And I think the judge took issue with authentication. We had to redo it and get the proper authentication from Mexico. So just a learning lesson there for you all, that if there are authentication issues, or if you're dealing with certificates or documents from abroad, it's important to look at that issue of authentication. Compliance with the Hague Public Documents Convention and other international agreements regarding these types of issues may also be necessary. Death certificates. Following an individual's death, there are a myriad of tasks that may require the use of a certified copy or a certified informational copy of the death certificate. You know, so many of you have dealt with this probably. For example, the state may need to transfer bank or other financial accounts, access safety deposit boxes, file insurance claims, record affidavits of death. And so there are various needs for certified copies or informational copies. Any interested person may obtain an informational copy, but only an authorized person, one of those listed there in red font, can obtain a certified copy. One point here also is that an original death certificate cannot be altered. However, amendments can be made to the official record. And so the way it works is when amending a death certificate, all of those additional amending documents become a part of the multi-page official record. I've had this come up at least once where the parties were disputing the cause of death on a death certificate. And so an amendment was sought by one of the parties. And the amendment to the death certificate will consist of the original document and all accepted amendment forms. And to change the name, cause of death of a decedent, you have to fill out a form VS-24A from the Office of Vital Records. And on that form, in the case of changing a cause of death, for example, the certifying physician from the original death certificate has to attest to the corrected information. So it can be very hard to change or amend death certificates when it's relevant. A death certificate must be filed with the local registrar within 8 days of the death and before the body is buried or cremated. One of the more convenient ways of obtaining death certificates is to ask the person or entity that files the certificate to order them for you. Typically, this can be the funeral home, mortuary, or crematory. And then, of course, if you need death certificates later, some attorneys, we run into instances where we need them long after the person has died, and you can request one from the California Department of Public Health website and download a mail-in form. Right. So the next section here that we have is on the topic of transportation, interment, and disposal of remains. When the certificate of death is properly executed and completed, the local registrar of births and deaths will issue a permit for disposition that specifies one of the following methods: the name of the cemetery where the remains are to be interred, burial at sea, provided under the Health and Safety Code section, the address or description of the place where the remains are to be buried or scattered, and the address of the location where the cremated remains will be kept. Those are the options. Transportation and shipment of remains. If the decedent's body has not been cremated, as I mentioned earlier, embalming is required to transport by common carrier. Mortuaries and other funeral services can help facilitate all of this in terms of getting permitting and facilitating the transfer of the body. Otherwise, in transporting and disposing of a decedent's body that's been cremated, the attorney and responsible parties should be mindful of several issues. So here, transportation and shipment of remains. As I mentioned at the outset, the TSA controls flying with remains. They have regulations that allow parties to transport ashes on an airplane, but each airline has different policies. Some airlines allow it, some don't. Some allow it as checked luggage, some don't. So it's important to check with the specific airline. The cremains will be screened by a TSA officer as part of the standard operating procedure, which includes examination of of the urn or whatever other container you have through X-ray devices. But please keep in mind that TSA agents are not authorized to open urns or other containers that can't be scanned. And so it's important that when you're carrying cremains through security checkpoints like this, that the containers be of a scannable material. The TSA.gov website has more instructions and advice on this. They actually say on the website that out of respect for the deceased, TSA officers will not open a container, even if requested by the passenger. So again, check with the airlines and read the TSA website for further guidance. So shipment of remains, the U.S. Postal Service is actually the only legal method of shipping cremains domestically or internationally, provided they're in the right kind of packaging. You can only use registered mail with a return receipt or express mail. I think technically it's the USPS's Priority Mail Express option or the Priority Mail Express International option for international shipments. And this includes not only human cremains, but for animal cremains, pets and the like, domestically and internationally. The post office requires the use of label 139 on all of the shipments. And again, they're allowed to be shipped, obviously, to an international address when the designated country does not prohibit the contents and when the packaging satisfies both the U.S. Post Office and the recipient country. For those who have this need, the USPS has on their website a cremation remains kit, and it includes all of the packaging instructions, publication 139 instructions. The kit is free of charge, and so you can use that to package up what you need. Customers can use a box of their own choice, but are required to use that label. All right. So interment and funeral arrangements, we've talked about some of this already. There is technically no legal property right in a dead body, but there is an obligation of burial, which rests upon certain individuals, either named by the decedent or set forth through the Health and Safety Code section 7100 that we've talked about. The individual, whether appointed under 7100 or whether designated by the decedent, has a right to control disposition of the remains, the locations and conditions of interment, and arrangements for funeral goods and services. Excuse me. The right to dispose of a decedent's remains under Section 7100 includes the right to private funeral and burial services. We've touched on that. The right is exclusive to the disposition and to protect the dead body from mutilation and desecration. And I've referenced some of the, the court's statements and public policies on this topic, and some of those are quoted here. The one in whom the right to control vests by statute has a right and the power to dispose of the remains without services, with public services or with services attended by invited guests only. Friends or family members who are uninvited have no right to be present. So, I've actually had a good number of questions on this point. Whether you can control, I feel like it's one of the bigger questions whether the person designated can control the attendees to a funeral. So the answer is yes, and it's been confirmed in many cases. Disposition of cremains in California, you may choose any of the following methods of the disposition of cremated remains. You can place it in a columbarium or mausoleum, burial in a plot at a cemetery. You can retain them at a residence. You can store them in a house of worship or religious shrine if the local zoning laws allow. You can scatter them in areas of the state where no local prohibition exists and with written permission of either a private property owner or the governmental agency that controls that area. The cremated remains must be removed from the container and scattered in a manner so that they are not distinguishable to the public. You can scatter in a cemetery scattering garden, and you can scatter at sea. So I think depending on the type of water that you want to scatter in, whether it's state regulated or federally regulated, there are different laws and regulations that you must abide by. Disposition of cremains. Cremated remains may not be transported without a permit from the county health department and may not be disposed of in a trash bin. Cremated remains may be disposed of or scattered pursuant to health and safety code sections listed here. And generally, they may be scattered in any area, like I said, where there's no local rules, where private property owners allow it, or where the governmental agency allows it. You do need permits. A permit for disposition must be obtained from the local registrar. And then within 10 days of scattering, you have to return the payment, or not the payment, the permit for the disposition endorsed with a final disposition date and return to the local registrar. You have to do that within 60 days. Disposition of cremains at sea. And here's where there's some technical definitions for different types of water. The term at sea is defined as the inland navigable waters of the state exclusive of lakes and streams, provided that no such scattering may take place within 500 yards of the shoreline. You do need written consent. Those wishing to dispose of cremains in lakes, streams, bridges, piers, and other similar locations must obtain the written consent of the property owner or governing agency. I think it's common for people to just to dispose of cremains at their will, and there are wills that control, or there are regulations that control these issues. For disposal of cremains in state regulated waters, any person in control of the disposition is required to file a verified statement with the local registrar. And again, the verified statement has certain requirements for the information that's to be submitted. Disposition of cremains at sea. For disposal and burial of human remains in federally regulated ocean waters, the EPA has additional requirements. I referenced this at the outset, I think. There's a permit, a Marine Protection Research and Sanctuaries Act permit must be obtained prior to disposal, and parties must notify the EPA of the burial within 30 days. Interestingly, the permit can authorize disposal of both cremated and non-cremated remains. The placement of human remains is within 3 nautical miles. It is not permitted. You have to go beyond the 3 nautical miles. And non-cremated remains may be disposed of at sea. So that's just a dead body. You can dump it over the side of a boat if you so choose to, if you have that authority. But you have to take adequate measures to ensure that the remains are weighed down and will actually sink to the bottom of the ocean. So that's one of the requirements that they have. Water cremation. Sorry, this is not starting last year. This was, I think, a couple of years ago. It became lawful to dispose of human remains through a process referred to as alkaline hydrolysis, aquamation, or biocremation. I don't know if you folks remember the Breaking Bad pilot episode where Jesse and the chemistry professor Walt are needing to dispose of a human body, and the chemist Walt says to Jesse, "Hey, you better remember to dispose of this body in the acids or whatever in plastic." And Jesse shirks that advice and he puts the body into a tub with the chemicals. And there's a horrifying scene where the body is, of course, liquefied in the acid, but then the acid melts through the tub and the whole thing comes crashing through the floor and the floor beneath that. It's a very dramatic scene. But this is a reality now. In California, you can use water hydrolysis, alkaline hydrolysis, to liquefy remains. And I think we're not the first to do it. There are a list of other states here that beat us to it, and it reduces the carbon footprint. What happens is they put these bodies in steel containers or other there's an oven-like machine that they can use. They fill it with heated water and potassium hydroxide or lye, and the solution speeds up the natural decomposition of the body. And at the end of it, what we're left with is just bones, pacemakers, implants, tooth fillings, things like that. The process takes about 2 to 12 hours. The bones then can be dried, pulverized into a powder, scattered. But again, the carbon footprint is minimal. And so I think with environmentally sensitive people, this might be a good option. Transportation, disposal. So this section, I'll just touch on some of the criminal consequences just really briefly for that relate to unlawful disposition of human remains. Of course, there's removal of dead bodies, unlawful disposal of cremains, unauthorized removal of personal property like grave robbers, and mutilation of dead bodies. For removal of dead bodies, anyone who removes any part of any human remains from any place where it has been interred, or from any place where it is deposited while awaiting interment or cremation, with the intent to sell it or dissect it without authority of law and without written permission, or with malice or wantonness, has committed a public offense, and it's punishable by imprisonment, Section 1170 of the Penal Code. For unlawful disposal of cremains, like at Disneyland, cremated remains may be removed from the place of interment for disposition as provided in Health and Safety Code Section 7054.6, or for burial at sea as provided in Section 7117. Any unauthorized disposal of cremains is guilty of a misdemeanor. Unauthorized removal of personal property for grave robbers. Anyone who removes or possesses dental, gold or silver, jewelry, or other mementos from any human remains without specific written permission of the person or persons having right to control is punishable by imprisonment and other penal code violations, Section 1170, for example. Mutilation of dead bodies. This one's kind of gross. Anyone who willfully mutilates, disinters, removes from the place of interment, or commits an act of sexual penetration or has sexual contact with any remains known to be human without authority of law. I don't know how that would ever be authorized, but the person is guilty of a felony. So everything else, it's a misdemeanor. Mutilation of dead bodies, that's a felony. Again, I do defer to my criminal attorneys on more specifics for that topic. Disinterment and removal. Under California law, there is well-established presumption against removing the remains of a deceased person, against disturbing the repose of the dead. That's a term that the courts use in this situation. No remains of any deceased person may be removed from any cemetery except upon court order or the written order of the health department with competent jurisdiction. The remains may be removed from a cemetery plot only with the consent of the cemetery authority and the written consent of the following individuals in the order of priority. Those are listed there. And sometimes litigation over disinterment ensues, and each case in those instances involving disinterment must be considered in equity on its own merits based on the particular circumstances involved. And there are a list of factors that the court considers in these cases. They consider the interests of the public, the wishes of the decedent, the rights and feelings of those entitled to be heard by reason of relationship or association with the decedent, the degree of relationship to the decedent of those opposing or seeking disinterment, the conduct of the parties seeking and opposing reinterment, especially as it relates to the circumstances of the original interment, the integrity and capacity of the person seeking reinterment to provide a secure and comparable resting place, any agreement with or regulations of the person or associations maintaining the cemetery in which the decedent is buried, and then lastly, whether consent was given by persons with authority to do so to the burial in the first place of interment. Interestingly, there's no requirement that the decedent's wishes override the other factors relevant to disinterment. I guess maybe that's because the situation is so rare that a person would say, well, I want to be buried here in this way, but if you move me, I want these factors to be considered. I think that's very rare. In the court's exercise of this discretion, a surviving spouse's petition, and there's a few cases on this, to disinter was actually denied, where the decedent's brother who owned the crypt objected. The surviving spouse had originally consented to the burial conditions, and the surviving spouse had delayed moving her deceased husband's body for 20 years, delayed the seeking of disinterment for 20 years. And because of the strong public policy of leaving the dead undisturbed, the court denied the request. This is the case of Maffei v. Woodlawn Memorial Park 2005 case, 130 Cal at 4th, 119. So as we've seen today, the treatment and disposition of human remains is a highly regulated area of law, and rightly so. I think well-established public policies that we've touched on today for the respectful treatment and protection of deceased citizens of the state have resulted in one of the most highly regulated statutory schemes of any state in this country. I think not only with this topic, but with our laws in general in California, it's one of the most robust case laws of any state in this country. And violations of these regulations can result in civil liabilities and criminal charges. As I said at the outset, I think it is a rare occasion that some of these come to issue, but that there are rights to petition for relief with the control and the mechanisms and the disposition of human remains as set forth in the Health and Safety Code sections. There are criminal consequences as referenced. Anyways, I hope you all enjoyed the program and found this to be helpful. Thank you so much for your time.
Thank you very much, Daniel. I'm Ann Wolf. I'm the Education Events Director for the Contra Costa Bar Association. I just wanted to thank everyone for their participation in this program today. Thank you, Daniel, for some very interesting remarks and some great stories. And I also wanted to thank Oliver Greenwood for being with us today to show us one way to get rid of a dead body. And thank you, Catherine, for your wonderful introductions. Right now, I'd like you to stay tuned for the live Q&A session coming up right after this with Daniel. But I first have a few announcements, sorry. The materials and the evaluation forms for this program can be downloaded from the session page through the Files tab, which is above the chat. Attendance certificates will be available after the Thanksgiving holiday. If you are a CCCBA member, your attendance certificates will be on our website in your member profile. If you are a non-member or would like more information on how to get your attendance certificate, look for the information under the FAQ tabs on the main screen. Also, for assistance with any technical difficulties, please head to the FAQs tab on the main screen. So now you're invited to join the live Q&A session with Daniel. Below the screen on which you're watching this session is a link that will take you directly to the live Q&A. So now click on that link and I will see you in the Q&A. Thank you very much, everyone.